Okay. As is usually the case with our live streams, we'll give everybody 30 seconds or so here just to kind of click over from the email link or wherever they're joining from. Anybody who's here now joining us, I see a couple people filtering in. Appreciate you taking the time to be with us this evening. All right. So without further ado, I think we can get rolling on this. Danielle, thank you so much for joining us, and thank you everyone else for being here. This conversation is going to be about artificial intelligence, part of our ongoing series. We welcome you to another CMA Presents. We're unpacking what AI is and hopefully arming all of us in kids media with relevant ideas and knowledge that will help us prepare at least just that littlest bit more for what is shaping up to be a rapidly evolving future for us in children's media and media at large. Last time, if you joined us, we spoke with Professor Selmer Bringsjord about the basics of what AI is and how it really works, as well as what its limitations are. So continuing out of that conversation with our terms a little bit clearer and some more context as to what's even going on, we're going to move into how it specifically impacts us today in the media industry. The idea of fairness comes up a lot, and we want to get to that with the legal ramifications of how generative AI works and what sorts of safeguards there are, how this is being addressed in the legal community, and how things like guilds and other unions are working for protections, and then also just understanding what kinds of things are already on the books. So here to help us today with these kinds of questions and more around the topic of the law and AI is Danielle Van Lier. She's an intellectual property attorney who focuses on entertainment law. She served as counsel for SAG and SAG-AFTRA post their merger regarding IP matters for almost 24 years and has studied the effects of potential legal considerations for AI and other advanced technologies in the media landscape, particularly at the University of Edinburgh, where she obtained an LLM. Danielle also holds her degree in law from Washington University at St. Louis and continues to research and counsel on IP and technology matters to this day. We'll start with a guided conversation with her, and then after about 45 minutes or so of that guided conversation, we can take some questions from the audience. But we'll start with you, Danielle, if you just want to tell us a little bit about yourself, what you do and what kind of work you're involved in, and how you got involved in that sort of work.
Yeah, sure. So as you noted, I was at SAG-AFTRA for just shy of 24 years. I left earlier this year after the last round of negotiations and the strike, and going into working on video games and everything. And it was time to make a change. I just got my MBA, actually. In addition to the LLM from Edinburgh, I got an MBA, and so I kind of am pivoting my career. And at the present, I'm doing a lot of consulting on AI with clients that run the gamut from consulting and legal, run the gamut from like individual actors, writers, and directors, working with some of the unions still, have worked with some technology companies. So that's kind of my current interim practice, trying to figure out, where I go for these last decade or so of my career. But for now, this time I'm doing a lot of consulting. So I started working on not just AI, but image rights issues. And in addition to other intellectual property with, while I was at SAG-AFTRA, we got very involved in doing stuff in the context of rights of publicity. I filed, a lot of legislation. We participated in amicus briefs and a number of, which are friend of the courts briefs for those who are not attorneys, to help explain bigger picture issues on some cases in connection with rights of publicity or other image, name, voice, likeness rights issues. From that, as things started changing, there were a few big cases in the video game industry involving like college athletes and their rights of publicity, and we got much more involved. And then when I did the dissertation, you mentioned that the LLM that you mentioned, it was based on innovation, technology, and the law was the subject matter. And so my dissertation was finished that in 2019 and wrote the dissertation on deep fakes and the threat they pose. It was the title, which my dissertation advisor came up with, not me, but it's deep fakes as a threat to freedom and democracy, something, and is the law prepared to respond? And that was predominantly written from the UK perspective because it was a school over in Scotland, but researched very heavily US and EU and some other jurisdictions. And I've been working on these AI generated content issues as a major part of my work ever since then. So that's been going on about 5 years now, and was very involved in some of SAG-AFTRA's initiatives in that space. So it's kind of the long story of how I got to this particular topic.
No, it's great to know that you have such a solid foundation in particularly this kind of law and these kinds of concerns. It's, as I alluded to at the beginning, something that when I was planning and hosting the first event, I got a lot of questions about, was like, is this legal? And like, what kind of laws are there about this kind of stuff anyway? So very interested in having this conversation. And moving into specifically the kind of law that you do, just to lay a framework for everybody who maybe doesn't have as much context, what is intellectual property? That, you practice intellectual property law, you counsel media organizations on that. What is intellectual property in terms of entertainment and the arts?
So in the realm of my practice, it tends to be copyright, trademark, and right of publicity predominantly. Patent is also considered part of IP, but here in the US, at least, it's very specialized, and you have to have specialized background for it, which is usually science and engineering. Not my background. My undergraduate degree's in Japanese, so
Nice, okay.
language, literature, and cultural studies. So those are kind of the core areas, and patent does have some relevance in this area, but again, that's way outside my realm. So we're really looking at copyright, which protects the expression of ideas. Most people are familiar with the basics of that. Trademark, which protects brands mostly, but also can protect individuals. And then rights of publicity, which you hear a lot these days about the college athletes and their name, image, likeness rights, which is a aspect of right of publicity. It also can protect voice and your persona, the breadth of it. It's a state-based law. And there's some other aspects that fall under rights related to intellectual property, which might be like trade secrets or similar stuff, but those don't come up as much in the context of what we're discussing.
Got it, yes. And to that point, which forms of IP are relevant for the conversation that happens around AI, particularly, and entertainment law?
Yeah. So that would mostly, the two that mostly come up tend to be copyright, both in the ingestion of training material and in the output, and then rights of publicity, because you're dealing with a lot of content that, especially the stuff I was working on early on, which involved deep fakes, which I like to distinguish deep fakes. That term gets used so broadly. Just kind of digressing a little bit for a moment.
Yeah.
The term deep fakes, I kind of cringe when I hear it used in relation to consensually created content, because it has its origin in this very dark, non-consensual content that is like sexually explicit, abusive content. I prefer to use, something along the lines of like digital replicas, is the term the SAG-AFTRA contract uses, or AI generated content, something along those lines, just to distinguish between the non-consensual and the consensual.
Right.
And you also do, so, with the image, the rights of publicity do tend to be a very widely used, because also, and it's not just the non-consensual explicit stuff, but you've got a lot of fraud content involving celebrity likenesses and stuff. So rights of publicity and copyright seem to be the two that I am seeing come up the most. You're also seeing a little bit of trademark, because some of these apps are generating like, logos and stuff like that. One of the big lawsuits out there had allegations of trademark infringement because the content that was being generated had watermarks in it from the company that was involving Getty Images. So those are the three. I mean, all those three do come up, but copyright and rights of publicity do seem to be the bigger two so far.
Okay, makes sense. And so moving forward to what I think is probably at least I work a lot in animation. A lot of us in children's media touch animation a lot, and visual arts, and those are involved in a lot of things that we're doing as an industry. This idea of web scraping and training data being taken from, like you said, things that are protected by sometimes copyright or rights of publicity, and potentially being used in models that then are producing things for commercial applications. Can you talk about what legal limitations there are on this process of model training, or are there any?
It's a good question. It's kind of, that's one of the areas where I think there's like 30 something cases right now pending on
Wow.
content that has been used. And those are just the ones that I know of for content relating to content having been used as training data. For those who don't know, I'm not an expert on the technology of how it works for scraping, but my understanding of it is, essentially they call them, crawlers at times, so they literally go out onto the internet, either create links to the content that this data set can links to it, as opposed to actually grabbing the data itself. And then the third party user that comes along to use it, they're the one that actually, so that would be like a lot of these were, let me step back a second.
Sure.
A lot of these databases or data sets were created in a context of academics and in research, and have later been released out to the public. And if you look at some of these data sets, at least the ones I've looked at, it's not like they have the actual content there. They're just indexes and art of what is out there. So but they're like massive, massive indexes. So not too different from like the Google search algorithm, right? Google goes out, scours the internet and indexes the data that it finds. That's how it knows how to find different pages. And so what these data sets are doing is very similar to that, but then they're providing ways for third parties then to come and capture the data and actually download it into their systems to use for training. There's the legal limitation. Well, there is a technological tool that website users can use. There's a little piece of a text-based file called robots.txt. And what that is that sits on your website in the background there in your the directory of your website, and it tells these search engines or these crawlers and tools like these parts of my website are okay to index, so you can look at these, but you can't look at these ones. So things that might be behind a paywall or, whatever, maybe it can't get to. So, anybody can set up those sites if your web host permits it. Mine, I don't know if I have it honestly turned on any of my websites because it's of how they're configured, but that tells the crawler whether it can or can't index your site into these databases. And, the purpose of these originally, this piece of text code was to allow, the search engines to discover you. So if you turn them off completely, Google is not going to find you if you want to try to block these other crawlers. So right now there's really like no way to stop it without kind of hiding from the internet, from my understanding of it.
Right. It would like tank your search engine optimization for your site.
Yeah.
That kind of thing. Right? Okay. Gotcha. Interesting.
But so it's a little, there's complexity there as well in the background as far as, how the data sets work. But generally speaking, my understanding of a lot of the data sets is that the party compiling the data set is just creating this index, of, so directory, like an old school telephone book, basically, of where to find everybody and everything. And then, then these other companies are coming along using a tool often provided by these companies that are scraping and indexing, but they're using a tool to then harvest the content and build it in, and then train on it. And, there are different theories on whether the crawling part of it is the cases have generally said that that's allowable in most cases. The scraping and pulling of the content, though, is a different story, and that's where we're seeing all the litigation, where they're arguing that, well, this is copyrighted content, and now you're actually accessing and using the copyrighted content as opposed to just indexing what is on there. And it's hard to say. I mean, some of the elements of these cases have been, to some extent, they've been dismissed for, on various bases. Some people will argue it's fair use under copyright law, which allows, because there are past precedents involving like Google and, their little like thumbnail images that they use, and the Google Books case involving, capturing full text of books and making it searchable, and not, as long as it's not displaying it. So it's going to be interesting. I think next year we'll have better understanding of where the law is on this.
Yeah, that's very
if
interesting.
That makes sense.
It does. Can you go into the Google Books case, like just for people who don't know what that is, but what happened there?
Yeah, gosh. Okay. It's been a while since I've actually read the case itself, so
sure.
I wasn't. I haven't refreshed.
Overview.
Yeah.
Of your understanding of it is more than sufficient. Yeah.
Yeah. Basically, I mean, there's a few elements to it, but they were sued by, was it the Authors Guild? They were sued because what Google was doing was creating full text, searchable copies of like every book imaginable, right? And when you can't read the full book on Google for the most part, unless they have consent for that. But you can search and it'll display like excerpts from the books and stuff, and you can see parts of it. And so the argument was that was fair use in how they were doing it, because it's not, even though they're copying the entire book behind the scenes, they're not displaying the full book. So it's like limited access to the book. And it isn't a market replacement for it. And just you go through the various factors, and the court basically held that the way they were doing it was fair use, if I'm recalling correctly. I could be conflating multiple cases.
Okay, but yeah,
because I wasn't.
Regardless, that and similar cases have sort of set up the standard for the way things are being looked at now, I guess. Yeah. Okay. Interesting.
And I have to caveat that I'm highly jet lagged because I got back 1 a.m. from Toronto last night. So,
jet lagged or not, you certainly know more than us. So that is definitely, it is definitely welcomed information.
Although it is possible I'm missing that particular case there. So
no worries. So to that point, I do want to get to particularly things like image generation or voice generation that have used copyrighted materials in their data sets. It seems like places like the really popular ones, I guess, are OpenAI's ChatGPT and things like Midjourney, but then of course Google Gemini and things, right? They seem to have included copyrighted materials, otherwise not intended for like maybe being used for other commercial purposes in their training. Does that mean essentially artists' work has been included in model training, and does that mean that's perfectly legal for them to do that right now? Or are companies breaking the law by using people's art that they don't have permission to use?
I'd say yes, maybe, maybe.
Okay. Okay.
I think it's, I mean, as we can see from the litigation that's been out there and how some of these have proceeded, I think, and it's even fairly obvious that, because there have been admissions to it and otherwise, it's pretty apparent that the work has been used in training, right? And in training these models. In the New York Times case, they were able to get it to, regurgitate things that New York Times writers had written in other cases. It's generating, you can generate art in the style of so and so. It's one of the big cases. I think that's the case against Midjourney, maybe. And so it's very clear that it's been, and even just data sets that have been, these data sets I mentioned that have been released, people have created, a reverse engineered database where you could search to see if your content is in there, and people have found their content. So it's very clear that people's work has made its way into these training model and into the models as they've been trained. Whether the extent to which that has affected the models, et cetera, is, I think, a matter of debate, both in on the legal and technology side, right? There are those who say, well, yeah, sure, we've taken this information in, but these models are predictive, so it's not like it can simply regurgitate somebody's art. It just learns from multiple different art, styles and images and works, and it will just anticipate what the next thing, how it works, right? It's and what it should look like. If you say generate a picture of a bunny, if you don't give it any other guidance than that, it's just going to go through, how it's been trained on what a bunny looks like, and is going to generate pictures that not necessarily ones that are going to look like anything. I mean, anything specific, any specific artwork, but, based on like the tags in there. Again, I'm not the technical expert on this,
Right.
But it is pretty unquestioned at this point, I think, that the training has happened. And although I guess it was at OpenAI that was asked if it trained Sora on YouTube content, and they said they didn't know. It's so, I mean, I think there's some pretty clear evidence that things have been. As for, sorry, my brain just blanked. The question of whether it's illegal.
Yeah, right.
And I think that's where the cases are going to depend. I mean, there are some people who feel there's not much we can do to prevent the training on the data, right? I mean, we can't stop. They're clearly doing it in other countries. Some countries have exceptions under copyright law for training data, and I think until there are, agreed international standards on that, there's nothing that can be done. You can't really unring that bell either. I mean, or what is the saying, the horse has left the barn, right? You can't really bring it back in. Those models are out there. And I don't know that I can see a court saying these companies have to unwind their models completely. But you also have to look at it at the specific models, because and again, this is my non-technical, as my lawyer understanding of the technology. You've got the foundation models, which are the ones that form, just like they're called, they form the foundation of other models. And those are not the ones that the public is accessing. And a lot of the training there, those are the ones that require copious amounts of like internet-wide data. And then on top of those, you have more fine-tuned models. And I think if we saw fine-tuned models, like one of the examples I've given before is if somebody created a fine-tuned model that was trained only on Star Wars universe content, and so all it was generating was Star Wars content, I think you're going to run into a different question than these more general ones like ChatGPT or Sora that are can generate anything. I think we also see that some of these models are putting guardrails in place to prevent copyrighted, the use of like characters or individuals. So
Yes.
I've,
Yeah.
yeah. So I think like at one point, if you asked it to generate a cartoon beagle, you were most likely going to get Snoopy, right?
Right.
But now they've put guardrails in place where you're not going to necessarily get those same images, except for the new one that was just released by the company formerly known as Twitter. Their Grok image generator has no problem generating copyrighted character or trademark characters. I got it to generate an image with Mickey Mouse and Darth Vader in a conference room.
And this
and it
just,
has no
this just
problem.
reminded me of this image here I'll share now that I had done the other day. I'm a massive SpongeBob fan. Just as an example for the audience, if they haven't tried something like this, I said, hey, chat, this is to ChatGPT. Hey, chat, can you generate me an image of a cartoon character in a 90s animated style? I would like for them to be a sponge wearing brown trousers and a white shirt with a red tie. And it added his house. It added the sky background, the sand, everything. It filled in the gaps somewhere in the model. It was saying, okay, he's talking about SpongeBob, obviously. So we're going to give him
I
SpongeBob.
take back what I say about guardrails. I was under the, my understanding is that it doesn't, but you didn't use the specific prompt either. So,
right. Now, as if you use the words, I've noticed it has a problem getting that out, but yeah.
Yeah. And that does concern me because those are, and that's one of the questions that I think is an open issue is like, now who's liable for it? Is it you?
That was my next question. Yeah. And it kind of gets to, we've had Wild West moments in the past with things like streaming and music and file sharing, something like Napster gets ahead of the law and
the internet itself.
Right. The internet itself is, of course, a huge one, social media with news and things like that. And there's all kinds of ramifications for these sorts of things. But are we at a similar moment right now in your view is it like kind of a Wild West moment where we've really outpaced the law to a certain extent with what the technology is doing?
I mean, I'd say probably. I mean, it's the law, at least in this country. I mean, you see the EU has passed its AI Act that includes robust regulations. They've, some of the EU countries are looking at product liability type laws around AI. But here the law moves very slowly typically. I mean, we did get in California, for instance, there are, and New York, there's some laws in the books on some of, to respond to some of these things, especially the non-consensual deep fakes, for instance. But yeah, I mean, I think it really, it's hard to say, right? Because the law is, especially like with IP law, it is malleable enough to be, molded to the situation. But the courts move slowly. Litigation can take years. And so we're at a state where it's still making its way through the courts as the technology is advancing faster, right? So, we've got these cases, 36 cases involving these big training sets and algorithms and apps and stuff. But those, who knows, they could be outdated by the time those cases make it through the courts. It's really, I think this goes beyond the Wild West of the file sharing days because of the speed at which the technology is advancing. And it's really like a printing press level shift, or just advent of the internet level shift, right? On steroids. So it's really hard to say on that.
Gotcha. And so if I am an artist or I am of any kind, whether visual or voice performer or whatever it is, are there things I can do to protect my work right now from, if I say, you know what, I don't really like the way the model training thing's going. I don't like how AI art is working. Are there things I can do to protect my work from being included in that? Or
there are, again, I'm not the technical expert. There are tools. So one is, like I said, this robots.txt file on your website, and making sure that it's not allowing scraping from your site. It's only stopping the companies that abide by that. I mean, there are companies out there that will just scrape anything and ignore that little piece of code, but that will help. When you're entering into, like, so we were talking before we started, I do photography on the side, and I've got some of my photography up on like Shutterstock and Getty's. I'm blanking on the name, iStock. So I've got my photo Alamy photos out there, and all of them, started using their libraries that, if you haven't specifically opted out, they can use your photos to train on it. So the point there being that you need to read the terms of use of anywhere you're hosting your content. DeviantArt, which is a big place for graphic artists and other artists that do a lot of digital work. I know people that host content on DeviantArt, and one of the lawsuits that was filed included them as a defendant because at some point they made a change to their terms of use saying that they were allowing training on their users' content, and I think they were even licensing it out. And all of the big social media platforms now as well are either training on your data and your content, or some are licensing it out for it. I think it was Twitter or X that recently said that they can, license out the content, not just share it, not just use it themselves. And so you just really need to read the terms of use and pay attention to that and decide if you want to keep your stuff up there. I think Meta does it too, if I'm not mistaken. And so if you're on Instagram, and I'm sure TikTok, given that there's even fewer guardrails. Well, China does actually have some decent domestic AI laws from my understanding, but any of these platforms that you are bound to whatever you agreed to in their terms of use, and they can change the terms of use. They usually have to give you a certain amount of notice, but usually they just post it on the website saying, hey, our terms of use are changing. Be sure to check out what it says, maybe with a link or a summary. So you have to just figure out. From a technology side, there are a couple technologies that have been developed, especially with visual artists, not necessarily video. But there's one called Glaze, and I know one of the developers of this, but Glaze will overlay a glaze over your image. And so when the AI reads it, it thinks it's something else. And so, the photo behind me is, as I said, was a Croatian sunset, a photo I took outside of Dubrovnik. And, they could make this look like it is something different, like it's the ocean itself or something. And then there's another tool by the same researchers called Nightshade that will actually potentially poison the algorithms.
Oh, geez. Like the plant. Yeah, there you go. Yeah.
Yeah, nightshade, like the mushroom, right? Fungus.
Like I forget what it is, but I know that it's poisonous. Yeah.
Yeah, exactly. And I commented on that to him as well. But that one also will can harm, within enough content, if it's used enough, can kind of poison the algorithm into thinking it's one thing but not, and preventing it from learning from the content that's being developed. So there's these tools, and I'm sure there's others out there. Those are the two that I, because I know one of the people involved with them. But there are, becoming solutions for that.
Got it. That's very good to know. And sort of in keeping with the idea of protections, current union agreements about AI. What can you tell me about these kinds of agreements that have been struck already with the different unions? What is your familiarity with those, and what kinds of protections are there in there?
So last year, as anybody in the industry knows, the
Right.
two of the unions were on strike for quite a while. I was still working at SAG-AFTRA at that time. So all three of the major above the line US unions made deals finally with the studios that by the end of the year that set forth terms and conditions for the use of their members' work in AI in film and TV and signatory projects. And the directors guild agreement is largely focused on preserving work opportunities and their creative rights. So AI can't be used in place of a director or in place of a director's team. The writers really focus largely on not having their wages degraded. So one of the concerns was, for instance, that they would be given an AI generated script and told, here, do a rewrite of this, and getting paid a rewrite fee instead of a full script fee.
Right.
So they got protections relating to, when AI generated content can be treated as source material, and ensuring that they have wage protections and that there's, it's disclosed. They can't be forced to use AI tools in their writing other than like plagiarism checkers and stuff like that. I'm trying to think what else. And then, there's some reservations of rights, and they couldn't reach an agreement on the use of the members' work for training data. But they did reserve their rights on that. And then SAG-AFTRA is the most complicated. It took up 16 pages of, I think, of the, about a tenth of the whole memorandum of agreement package was AI. And that created terms. It created three different types of digital replicas. It set terms for using AI to alter performances and footage, and then it also set terms for what was called a synthetic performer, which is when it's purely AI generated. And so it requires that, without going into too much detail and working from memory, it requires that performers get or producers get consent when they want the member to work to create the AI. So if they're going to be scanned, it sets terms for that. It sets terms for the form and content of consent for using a digital replica of a performer. So they have to, the term we were using during the campaigns for it was informed consent, which actually has technical legal meanings. So that wasn't the term that we ended up using, but it's like clear and conspicuous consent. So it can't be buried in like page 12 of a small print standard terms and conditions. It has to be clear. It has to describe in a reasonable enough detail how the digital replica is going to be used. So they can't just say, oh, we're going to use it here and there throughout the script. No, it has to be like in this scene for this purpose. And if they want to use it for something different, they have to go back and get consent again. If they want to use it in a different project, it's only limited to the specific project it's used for. So if you're doing, the next Star Wars trilogy, there are some ways you can get the consent for subsequent projects, but generally speaking, it's only going to be for that first film. And if you want to use it, you either have to very specifically say this is how it's going to be used in the second and third film, or you have to go back and get the consent again. And then set terms for compensation, which are for without getting into detail, it's kind of a reasonable approximation of the value of the work that would have been performed. So the number of days the performer would have worked that was replaced by the replica, as opposed to just a flat fee for it. They have to really reasonably approximate, oh, this scene would have taken a week to shoot. So the performer is entitled to payment for that week of work plus residuals, etc. If the performer is licensing a replica, because like CAA, for instance, has this program where they can create replicas for their clients and stuff, and then they house it. So say it's one of those kind of situations where, the replica is being licensed, or, some of the companies that SAG-AFTRA has made deals with, although those are for different media. But if they want to license a replica from the performer owns it or their agency owns it, there's different terms for that as well, that I still, again, have consent and compensation. And sorry, it's a little bit long-winded.
No, it's a lot of things that I haven't heard before. Honestly, I did not really like that replicas were already part of the system and pipeline for a place like CAA. I was not even aware. Well, because I don't do much live action work. I do mostly animation, video game stuff. But it's very interesting to hear that is part of the agreed terms already with the union. So.
And it's the center of the video game strike that's happening right now. Is one of the key issues is still AI, and but there's independent agreements with for producers that are not being struck. That
tell me about the sticking points for that. Where's the struggle?
I don't know where it stands, to be honest, beyond what has been said publicly. I know where it was about a year ago, a little bit less than a year ago. Yeah. But the main thing is, the extent of the disclosures that the companies want to make, what certain protections that are in place, certain types of performance, whether it's covered or not, and stuff like that. So I like I said, I don't know where it stands right now because I've been focused on other things. But it's a lot of the same issues that were at issue in the strike last year, but modified for a video game context. So one of the big differences, for instance, between the two media is with film and TV, in most cases, the performer is also going to be employed on that project. And then the replica might be filling in for a scene here or there as of right now. So the performer is going to have the script and know what the dialogue is. In video games, they might not have that because sometimes the scripts are being written as they're, doing the video games or as they're recording, and they don't necessarily get scripts ahead of time, video game actors, the way a film or TV actor would. And so, they want more disclosures kind of to explain. And this was even true, what was it, 6 or so years ago when the performers went on strike on the video game industry. This transparency was a big part of it. They want to know what their characters are saying, whether they're recording it live. They don't want to be in the studio and suddenly be given a line where it turns out their character is a pimp when that's, when normally they don't play that kind of role, or, right. Their character has offensive dialogue towards a particular, group or whatever. So, that's part of the issues is both for live action, not live action, but people who are recording in the studio as well as for their replicas. It's just knowing what the content is going to be.
Got it. Okay. So before we get into any Q&A from the audience, we can open it up to that now. If anyone has questions, you can go ahead and add them in the comments there, and I'll continue with our last couple of the guided discussion here while you all chime in. Legal ramifications for AI don't stop at the sorts of things that we've been talking about right now. What are some of the areas of law that we haven't really gotten into that are being impacted by AI already that are relevant for us in entertainment that maybe aren't as discussed because the model training is such a big thing?
It's a good question. I mean, really, the question of output is not as widely discussed just yet. because the focus has been on the input. And I guess I feel like a lot of the AI generated content is not quite, it's getting to the point of realism. Sorry, I just got news about a piece of legislation that just passed in Congress. Got a pop-up involving AI, but I don't know. I assume it has passed. That is public. But I know the Take It Down Act that allows people to have digital content taken down from the internet. I haven't really read the whole law closely, but it's one to go look at.
Oh wow!
Speaking of
that just got
useful timing,
as we asked. Yeah, that's really funny.
Or at least I just got news of it. So
sure, yeah.
At some point, it just it sounds like it was it passed Congress now finally. Wow. So there's a bunch of different areas. So the one, like I said, one of the key areas where I really started was with this non-consensual content. And I think this is one of the areas of where a lot of people are going to have to be paying a lot more attention. And to the point, some of the discussions we've had and with children and stuff like that, obviously there's a lot of, we've seen, kids using these apps to create, sexually explicit content using their classmates. Out here in California, I think there was one on the East Coast, was it maybe in New Jersey? And I think, so the law, that's kind of a grayer area of the law right now. And there is not much criminal law on point. Most of it is civil, especially for celebrities. So that's one area where I think we're going to, we really need to see some change. I've been pushing for change to the law relating to non-consensual sexual content since I started studying it. And then, of course, copyright, we're going to have questions about if the output infringes on somebody's copyright and who's liable for it. Is it the AI itself, the AI company, or is it the person who prompted it, and does it depend what the prompt is? And, we're seeing some jurisdictions and arguments being made that it should be treated like under a product's liability standard if it's generating dangerous or like false content. So you've got questions of defamation. If it's trained on content that could be defamatory, and it's spitting out stuff that's defamatory, who's responsible for that if, say, a news outlet goes and publishes it? And, a lot of the AI companies are touting their search capabilities.
Right.
But we're starting to see that it's not that accurate. It's not, that kind of, I guess Google is probably still one of the gold standards for it, but although their AI tool is not yet there.
Right. Has been more frustrating than the traditional Google in a lot of people's view, I think.
Yeah. And then another thing I just read recently, that a lot of the AI tools, even ones that have licensing agreements with media outlets, that it's incorrectly summarizing what journalists have said, and because it's pulling from aggregate sources, it's misattributing quotes, or it'll provide citations to one of these like blogs that summarizes articles poorly or that copies the articles.
Yes, I've seen that too. Yeah.
Yeah. And so you're starting, we're seeing a lot of like, it goes back to one of the things that I argue, and, being an organization that directs media towards children.
Right.
One of my arguments since doing my research, and it's not original to me, it's, one that I found in my research in the UK, was just the need for media literacy and critical thinking skills, which are highly deteriorating in our society. I see it even among my friends, and I'm Gen X, where they don't trust, quote, I don't trust the mainstream media. How much have we heard that refrain?
Right.
And they're relying on these smaller, quote unquote, independent media that really, are some guy with a blog,
Right.
or they're coming out of a Eastern European country that is creating propaganda.
Right.
And I think we've really lost that degree of critical thinking that I remember being taught in school.
Mhm.
And, don't believe everything you see, verify, trust, but verify even.
Yep.
Um,
Yeah. So I'm
and I think,
millennial. So for me growing up, it was Wikipedia, right? We were taught that. It's like,
right.
yes, you can look at Wikipedia, but you should check the links. Like, please don't just quote Wikipedia for your project or I will not accept it. That was like universal stance of teachers at the time.
Yeah. And when I teach a couple law classes, and I don't let my students cite to Wikipedia really. I actually did cite to it once in a court brief. But it was I was describing something as Jenga-like,
Okay.
and I could not find a description, from an official source on what the description of Jenga is. So I went to Wikipedia and I was
Yeah.
like, okay, Jenga is blah, blah, blah.
Yep. Feels like a
But it was,
solid use, if ever. Yeah.
it's non-substantive, just to
Sure. Yeah.
throw in that this is what Jenga is in case you don't know, Mr. Judge,
Right. Right.
or I
Right.
think it was a male judge, if I recall correctly.
Sure.
But yeah, I think, but we're also, look at some of the fraud cases recently that, you had one, you've got like AI replicas of Tom Hanks and Taylor Swift and Selena Gomez hawking, dental insurance and cookware. And people fall for this,
Yeah.
and because they're not thinking critically. Like, have you ever seen Taylor Swift do that, or Tom Hanks? And he's
Right.
had to go out there and say, kind of laughingly, he's been kind of hard to take it seriously sometimes. He's, like, I do not have a deal to promote dental insurance. This isn't me. This is fake,
Right.
But then the news cycle, it's gone the next day. So,
Right.
Yeah.
And then I think maybe one last question we have here is around existing legislation. In terms of things that are on the books regarding artificial intelligence, the regulation of its use, is there anything on the books, I guess, already, other than, I guess, this law that just passed
Yeah.
just now?
I'm just double checking that this is accurate. Yeah.
Yeah.
Yeah. Yeah, there is, there are some laws on the books. I know when we talked previously, you asked about like children and stuff like that.
Yep.
And I've seen, so I did a quick search and I didn't really have time to dig deep into that. But I did see a number of states have passed primarily dealing with like child sexual abuse content, what they call it, CSAM. So materials that involve like child pornography or whatever.
Right.
They've passed laws involving that. We saw, I forget what country it was. Was it Australia maybe, that is banning social media for kids. So we are seeing stuff directed towards kids in particular. Here in California, we got a couple of laws passed, and New York has similar laws. One kind of mirrors the SAG-AFTRA AI replica terms. So it requires, in order for a transfer of rights involving someone's image in a digital replica, image and voice in a digital replica, it requires that, they either be represented by counsel, or that they, or a union, or that they have a clear and conspicuous description of the use, so that there's like, so it's that form of informed consent. And that New York has a version of that. And, both New York and California now have laws. And I believe, New York and California for sure have laws relating to the use of digital replicas post-mortem of deceased performers, deceased individuals. A couple of states, I believe Tennessee passed the Elvis Act, they called it.
Okay.
Which extended their right of publicity to digital replicas, and it a couple of states have kind of mirrored legislation that's pending in Congress that's called the No Fakes Act, which sets terms, again, sort of in line with what SAG-AFTRA negotiated, but and SAG-AFTRA and the RIAA are among the leading proponents of this. That and there's the Human Artistry Campaign, which is a global consortium of performers and athletes groups and other groups involving. And this legislation, the No Fakes Act, would set terms along what needs to be similar to California's laws about the use of digital replicas, including in creative expressive works. That's still working its way through Congress. And
got it. So specifically in terms, it sounds like of matters of like your personal identity, I think, like, right? Like things like that. Those are happening more quickly, it seems like, than something like your own, like a character that you've made or something like that, or a particular artist's style. There's no kinds of regulations necessarily around the use of that, right?
Yeah. And I think, because I think part of that is because I think there's always a hesitancy to touch the Copyright Act in any great detail, but I think there is room to argue, like, the style is always a tough one. There's very little protection for style per se. But copyright will protect if they copy the artwork itself. I think the question in that largely is, who is the defendant? Is it like I said, is it the user? Or is it the app creator? So the more, in a way, the more pressing need is in that image and voice space, because there is less protection, and the risk for serious individual harm, as opposed to like purely economic harm, can be kind of high. Not that there isn't risk to, that any, like, using style or anything. I mean, even as a photographer, I hate seeing my stuff infringed. So I don't want to say that that's not a harm, but I mean, like, the use for fraud, that's going to harm a lot of people directly, in those kind of like really egregious, ugly ways. Again, not that the other forms of infringement aren't, but these widespread, financial crimes and stuff like that. There's a broader base for how that's going to impact it. And there is, existing copyright law will protect on the output. It's just the input that is where the biggest questions are.
Got it. And so in terms of, what do you mean by that in terms of the input? Like, I know
the training data. Yeah.
I see. Okay. Got it.
Yeah.
That question, those are still very open.
Yeah. I mean, I think that's the litigation that we'll see hopefully some movement on next year, and see what the courts are coming down with. Although I think it's going to be a longer term case, issue, because it's going to take a couple years to work up to the Supreme Court, maybe. I do think there's one comment, one approach that people haven't discussed, which is, if somebody uses, say, a photo of, or a particular artist's work, and uploads that artist's work into, because some of these, like I was playing with Sora, right, just to try it out. And I uploaded one of my photos, which was like a herd of wildebeest. I took that on the Serengeti. So I uploaded it and said, kind of, essentially, I forget what the prompt I used was, but it was like, animate these wildebeest, right? And it did a terrible job of it, by the way. I was like really surprised how poorly it did it. Yeah. But I think, and I tried it with another photo, that it did not follow my prompts, which probably is partly user error. But I do think that if somebody, like the user, uploaded somebody's photo and said, do it in the style of this photo, and try to keep it as close as possible, but maybe make this little change, turn it like purple instead of green, and do this. Then I think you have a different question, because then you're actually emulating that photograph, right? So I'm trying to think of a famous photograph or a famous artwork. you say Van Gogh, Starry Night, right?
That's
Because
exactly
that,
what I was thinking. Yeah.
yeah, his first one. And there actually is a situation at the Copyright Office relating to that. And granted, Van Gogh, that's not under, I don't think there's any copyright protection to that at this point, but let's say it was done yesterday and somebody took Van Gogh's Starry Night and said, put this, take this, animate it, and change the, this tree here and whatever.
Yeah.
Then I think you have a different analysis that would go into it, because you literally are trying to copy the specific photo, right? How you
Got it.
prove that, I don't know. But I think that's a little bit different than some of the prompts that are out there now.
Yeah.
But I think we'll know more in the next, within the next year. I think this time next year, maybe we'll have more answers.
Boy, I sure hope so. I guess we're at right about an hour now, so I just have one last question if we can go over just for a second here. But in terms of, because it came up, and this is just a question that came up to me that I feel like I'm certainly interested in, other people will be. What protections are there for something like style? You said that can be hard to pin down. When has anything really come into the legal system about protecting someone's style in particular? Like if I did something that clearly looks like it's a Dr. Seuss character, and I make a whole series of books that rhyme in the same cadence, would those be things that are clearly infringement for him or his
Not
brand?
necessarily, because and there are cases that go both ways, and I'm blanking on how I think there's two different Dr. Seuss cases actually in particular. And I think they came out, if I recall correctly, I think they came out on the side of fair use, at least at one. They either did and it got reversed, or vice versa.
Okay.
Because, and it was,
I know someone personally who was cease and desisted by the Seuss estate for that. So, but yeah.
Yeah.
Continue.
Well, the one I'm thinking of is, well, see, that's the thing. It's like the cease and desist, often is enough to scare somebody off. Because they don't want to get into litigation. But if somebody challenges back, sometimes it just depends. But I apologize that I'm blanking on my recollection is fuzzy right now on which way the Dr. Seuss case turned out. But I believe it ended on fair use. But the issue was it was kind of like it melded Star Trek and Dr. Seuss, right? And so it was like not confusingly, so I don't know where I put my phone to look it up, but it's right here. Gosh, I wish I could remember. Let me just see real quick as I hold, because I don't want to give the wrong, if I could type.
No problem.
Boldly.
We all love a little suspense in our media.
Yeah, sorry.
No, it's okay.
So it never made it to Supreme Court. The Supreme Court rejected it. Let's see, what does this say? Of course, it doesn't want to open now. Oh, okay. So I stand corrected. I knew it was one way or the other way. The Ninth Circuit held that it wasn't fair use, but the lower court, I believe, held that it was. And that one, so they said it because it wasn't transformative. So my apologies. I knew it was either.
That's what it always hinges on too, right? Is whether or not it's transformative, I think.
That's, and there's new, the transformative test has kind of gone up and down.
Something like this, for example.
There's nothing transformative.
Look, I made a new character. It would not be right. It would probably not work necessarily, right? Yeah. Okay.
Yeah, and I apologize for getting that backwards on the Dr. Seuss case. It was the lower court, I think, that held that it was, and the Ninth Circuit must have reversed. But yeah, so a lot of times if something is transformative, it has been held to be fair use. The recent,
so even in terms of like using a style, I guess it would be
style, because it's style is very hard to protect.
Got it.
But it's, it comes down to how much of it that you take. and how, like, with some of the, like your description, right? If it's very much looking like Dr. Seuss and sounding like Dr. Seuss, you also have that question of, you know, is there possibly a trademark infringement as well? Because, you know, could a consumer be confused to believe that Dr. Seuss somehow was, you know, Dr. Seuss Enterprises was somehow involved with it? So trademark can come into play with that as well. And style, when you're using like an individual, there are some cases in right of publicity where there have been some hints at protection, but it's also very, very difficult there. But yeah, style is a tough one. But one of the things, like even in the cases that were filed, if I'm remembering correctly, and again, my brain is a little bit fuzzy today after all the travel, but you know, the couple of the artists that sued based on style, part of the argument wasn't just that it was the style itself, but that they were prompting with that person's name. So part of the argument they were making is that, well, they're saying in the style of, you know, using my name. And so that also violates my, you know, potentially my right of publicity or,
oh, I see. Yeah, because I'm sorry to keep bringing this guy up, but nothing.
Now I'm going to go play with Chat GPT-4.
Nice. But nothing mentioned about Nickelodeon here. Nothing mentioned about SpongeBob in particular here. Something like this in terms of, you know, copyright protection on my end. You know, if you are really familiar with what happened if you're familiar with what happened in animation in the 90s, and that there was a sponge character who wore brown trousers and a red tie and was very famous, you would probably know what this person's going for. But in terms of rising to like legal protection for, I guess Nickelodeon would be the intellectual property holder here. Are they out of luck right now?
No, I mean, I think here you probably have a copyright argument, right? Because, or a potentially trademark argument, depending how it's being used, because you do have, like, I mean, that pretty much is dead on to SpongeBob, right? So, you know, I do think that there is a copyright infringement article argument as opposed to maybe a style argument.
Got it. Well, on that note, I will say we are about 7 minutes over here, but I could probably talk about this for another full hour. I'm very fascinated by it, and really am looking forward to continuing conversations on this with you and the rest of the community around AI for us. We're planning to get, for those interested, some people from the creative community to talk about moving forward with AI and what their strategies are and what kinds of plans they have for either not using it, protecting themselves, integrating it, all those different perspectives. So stay tuned for a follow-up event on that. But for now, just want to thank you so much, Danielle, for your very thoughtful answers. I think a lot of us are probably leaving with some clear ideas about what's going on, but surely some more big questions as well. And good to know that next year, it seems like there's a lot of things in the court system that we might hear more definitive things on, it sounds like.
Fingers crossed. And I need to go look up that Google Books case to make sure I got it right.
Okay.
Clearly, I'm mixing up my cases here. So
thank you so much for everything. And thank you, everyone, for tuning in.
For having me.
Yep. And we'll talk to you next time. Thank you so much.